Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. I am going to move on to introducing our panel today. It is my pleasure to introduce Judge Vedica Puri. Judge Puri has dedicated over 30 years to litigation and dispute resolution, first as a trial lawyer and then as a respected judge in San Francisco Superior, and now as a mediator. She built a distinguished career handling high-stakes civil cases, earning recognition for her expertise in insurance law, very relevant today, legal malpractice, and complex litigation. Appointed to the SF Superior Court in 2019, she presided over a wide range of civil and criminal matters, managing trials, settlement conferences, and intricate legal motions with fairness and efficiency. A skilled negotiator and problem solver, she successfully resolved hundreds of disputes by understanding the legal, financial, and human dynamics at play. Now focusing on mediation, she leverages her deep courtroom experience and evaluative approach to help parties reach a clear and practical resolution. Thanks for joining us today, Judge Puri, putting together this panel, and I'll hand it over to you to introduce our other speakers.
Thank you. Good afternoon, everybody. Great to have you with us today. It's weird for us panelists because we can't see you, but you can see us. That's okay. Katie was going really fast there because we have a lot of content to cover for you. It is with great honor that I introduce our other panelists. We put this panel together with a lot of thought because we wanted to give you all perspectives on coverage law. There are so many perspectives. So we have with us today 2 well-respected and seasoned trial lawyers who are versed in coverage. Let me start with the person I see next on my screen, which is Tamiko Dunham. She is a partner with the San Francisco office of Nicolaides, Fink, Thorpe, and Michaelides and Sullivan. Tamiko and her firm exclusively represent the interests of insurance companies in insurance coverage matters. Tamiko has extensive experience counseling clients on novel and complex issues across a variety of coverage items and issues. And in litigation, she has handled litigation coverage issues in state and federal courts. Tamiko is also the current chair of the insurance practice section of the Bar Association of San Francisco. She's also the vice chair of the Insurance Law Standing Committee for the Business Law section of the CLA, which is our California's Lawyers Association. Thank you, Tamiko, for being with us today. Great to have you here.
Very happy to be here.
And then Demián Oksenendler. He is also with us. He is the principal attorney for Oksenendler Law, PC. He has been representing policyholders of all kinds throughout California against insurance companies in both litigation and consulting matters for 20 years. He's an AV-rated lawyer and has been a Northern California super lawyer since he first became eligible. He is currently serving as treasurer of the SFTLA, that is our local San Francisco Trial Lawyers Association. And next time you see him in person, ask him about his karaoke trophy. No, I don't know if you should, but see what happens if you do. We also will be having a superstar guest cameo appearance by one of the Court of Appeal justices. I'm going to give him a much better intro later on, who actually authored one of the opinions that we are delving into today. So let me start us off, and we're going to be focusing on, as you've seen in the promos, an insurance company's duty to settle in the post-Pinto universe. So to start us off, let's just remind ourselves of the general rules that are involved here. An insurer's duty to settle within policy limits. It goes back to 1958, one of the originating cases, if you will, called Communal, where the California Supreme Court talked about imposing duties that come with the implied covenant of good faith and fair dealing. One of those duties is that an insurance company must accept reasonable settlement demands within the policy limits to avoid exposing its insureds to liability in excess of those limits. That's the general rule. Now, what happens if something goes sideways and an insurance company doesn't do that? Well, it's considered under many cases, but PPG Industries is one of those, to be a breach of the implied covenant of good faith and fair dealing if there is an unreasonable refusal to settle a third party suit. That allows the insured to sue for damages caused by that. So today, we're going to be talking a lot about what is and what is not reasonable conduct. It all comes down to that. And as coverage lawyers, which I was for many, many years before I took the bench, and then as a judge, we are looking for guidance. We're looking for what are the rules. We have a spectrum of conduct, and where does it fall on the reasonableness scale? So that's why we're bringing to you so many perspectives today. I know that there are adjusters in the audience. I know that there are attorneys, just like Tamiko and Demián, in the audience. And for us, coverage nerds, we're going to unite today and we're going to go through it. So the PowerPoint slides are pretty dense because they are taking pieces of the key opinions since Pinto, and we're going to talk it out. Just for framing, let's go to slide 3. These are the 3 key cases we're going to talk about today. We have to start with Pinto. We need to remind ourselves what that case was about. That just generally, it was a reversal of a jury verdict in favor of the insurer. This was decided on March 8th. I put the date in because fast forward to the next case, Planet Bingo versus Burlington, it was decided 10 days later by a different district, a COA. This is the 4th district. And it didn't cite Pinto, but it was a reversal of a summary judgment in favor of the insured. And then our final case today, the one we're going to spend the most time on, is called Hedayati versus Auto Club. IEAC is the longer acronym. Katie, I just want to make sure that we have our panelist. Is Tamiko still with us?
Yeah, I see that she dropped off. I will deal with that. We'll get her back on.
Okay. We'll keep going and Katie will handle that for us. And so Hedayati does not cite Pinto. It does cite Pinto. In fact, it's the only Court of Appeal published decision that really delves into Pinto. But it does not cite Planet Bingo. And it was decided in August of 2021. 2021 was a big year for the insurance bad faith universe. So this is just a framing slide so you can see what we'll be talking about. I'm going to go through, we're going to start with Pinto in a minute, and then I'm going to toss it to our panelists to kind of give their thoughts and impressions, what struck them about these cases. That's how we're going to handle the panel discussion today. I know that there's a chat function. Katie is going to help us with that. If there are questions that are coming in real time that we can handle for you, we will. So starting off with Pinto v. Farmers. Now, I know this is a very complicated, detailed timeline. A lot of these slides are meant for you to look at and have in your files after our session today. But the timeline in all of our panelists, we all felt that the timeline in Pinto was very critical, that it drove the decision that was made. So that's why we have gone through in detail in the 2013 timeframe and told you what happened with the claims handling. If all of you remember, this was a terrible car accident where a truck actually flipped. The plaintiff Pinto was rendered a paraplegic. At the beginning of the case, and actually almost through the case, there was a question as to whether or not Martin or Orcutt were the drivers. That became clear right away. Nobody quite knew. There was drinking involved. There were drugs involved. So the claim gets tendered to Farmers pretty quickly on April 9th, 2013. A claims adjuster calls for any information that they can get. Then towards the end of April 2013, adjusters, okay, great. Tamiko's going to be back with us in a moment. She knows this backwards and forwards, so I can keep going. Adjusters interview the key people, Orcutt, Martin. This is now still in April 2013, so everything's proceeding in a timely fashion. Then comes July, where we have Pinto's attorney who sends a demand letter on behalf of Martin. It gets mailed to the Farmers Oklahoma office for whatever reason. None of us are quite sure. And there's an expiration date that's put on it. There's a clock. So again, one of our key focuses today will be time limit demands. Obviously a big issue for plaintiff's bar, defense bar, insurance companies, it's the key in how you handle those. So Pinto's attorney sends the demand letter. We go to July 5th, where Farmers receives the demand. Farmers assumes that the demand is made on behalf of Martin and Orcutt. We know key issues in dealing with a settlement are making sure that we've got all the insureds taken care of so that we don't have someone hanging out there. Farmers forwards the demand to the insureds, Martin and Orcutt. Now, we can't find Orcutt apparently, so Farmers hires a PI firm to locate Orcutt. They call plaintiff's counsel to say, hey, we need an extension of time. And this is another hot button issue. This happens all the time. You're going to get a lot of time limit demands. You're going to put in calls perhaps to say, we need more time to get the key things together to be able to satisfy and give you an answer, yes or no. This is all very important to document what you're doing, when the demand comes in, what you're doing to figure it out. So here on July 11th, the evidence was that plaintiff's counsel was called by Farmers 3 times for an extension, but there was no response. So clock is on, clock is ticking. We get to July 13th. Farmers has located Orcutt, now confirms verbally with her that the key things required for the settlement to go through, i.e., that there is no other insurance and that she was not acting in the course and scope of her employment at the time of the accident. They're asking her for a declaration because that's how we confirm these things through evidence, but she never submits one through the life of the case. But Farmers does get the information they need. July 15th, Farmers sends a letter tendering the limits, but also asking a series of questions. So now let's move to, that's the claims handling timeline. Let's move to what happened procedurally in the case. The case goes to trial. Pinto obtains a judgment against the driver, it should say, in excess of the policy limits, like way in excess, 9.93 million. Owner and the owner of the claims, the driver, assigns her rights to go against Farmers to Pinto, and then Farmers is sued for bad faith. Fast forward to the trial. There's a lot of evidence presented by both sides about the reasonableness of Farmers' conduct with respect to that entire timeline that we just discussed. Tamiko, are you back with us? Just want to make sure we've got her with us.
I think she's
see
coming.
her. Okay,
Judge,
she's coming.
do you want to give the crowd a little bit of a understanding of kind of why there's this two-step process, the underlying and
Demián, take it from here.
well, okay. I didn't mean to volunteer.
No, I love it. This is the point of the panel presentation.
So where we are on the procedural history, it's just, because I know we're probably going to have folks that have a variety of backgrounds here, is that, one of the things that can happen is that if an insurer fails to settle within policy limits and then there's an excess judgment, under normal circumstances, right, just by the book, that judgment is the obligation of the defendant to satisfy, right? That's a judgment that the plaintiff has obtained against them. And so, right, in this particular situation, you had Martin and Orcutt who were the defendants. So why is this case that we're dealing with now called Pinto? And the reason is that the law allows for the insured to assign their claims against their insurer to the plaintiff who sued them. It's just like it's an intangible right that they possess and that they can turn it over. And so then the plaintiff in this case is Pinto, the injured party. They owned the defendants, the insured's rights to pursue the carrier for the harm that the insured suffered due to the carrier's alleged conduct. So that's where we're at now in the story.
Thank you. No, thank you. That's an important point. No. And that's exactly right. I think all of us who have done coverage for a long time skip over some of the fundamentals. So thank you, Demián. That's really
and it's tricky because there's certain claims that aren't assignable, like punitive damages and emotional distress, and there's some that are, and then the structure of what those type of arrangements look like are tricky and complicated, and you need But agreed. That's kind of how you get to this.
Agreed. So I'm gonna get us through what happened in Pinto, and then I'm going to toss it over. And Tamiko, I'd like to hear your thoughts as well. No, don't be. That's great. Okay. So at trial, there is a lot of evidence about that timeline that we just talked about. Was it reasonable? Was it not reasonable? Should the offer have been sent without the questions? Should it, was it really a tendering of the limits if there's a bunch of questions attached to it? The trial finishes, and there's a special verdict form that was hard fought. The records show that there was a lot of argument to try to figure out what the special verdict should look for. And the missing ingredient, as the Court of Appeal told us in Pinto, was anything about bad faith. So specifically, we pulled this actual special verdict form, and it asked 3 questions. It said, number 1, did Pinto make a reasonable settlement demand? You can see how the jury answered that. Number 2, did farmers fail to accept a reasonable settlement demand? The answer was yes. And then 3, going to what Demián was just talking about with the judgment, was a monetary judgment entered in the case for a sum greater than the policy limits that was assigned to Pinto? 3 questions. Those were answered all in the yes. Verdict came in, judgment was issued based on that verdict, and it was appealed. Now, fast forwarding to the Court of Appeal decision, they said, wait a minute. And here are some key quotes for you. I'm not going to read every single one, but there are some important ones that we've pulled out here. Simply failing to settle does not meet the standard. A facially reasonable demand might go unaccepted due to no fault of the insurer. For example, if some emergency prevents transmission of the insurer's acceptance. Most important is that the court has never held that a failure to accept a reasonable settlement is per se unreasonable. The special verdict form was patterned on CACI 2334, a version of CACI 2334, I should say, because that's how you do it. You do a verdict form based on a jury instruction. You fight it out with the judge ahead of time. And what the Court of Appeal held here in Pinto is that, okay, we see the 3 questions and the 3 parts of 2334, but it's lacking a crucial element, bad faith. To be liable for bad faith, an insurer must not only cause the insured's damages, it must act or fail to act without proper cause. For example, by placing its own interests above the interest of the insured's, which we can debate what the heck that means too until the end of time. But what the Court of Appeal was telling us is CACI was not the right instruction the way it was structured. And ultimately, there was a reframing and amendment of CACI. We're going to get to that in a second. Here are some other, we thought, as a panel, key quotes from the Pinto case about farmers' conduct and that what they had or had not done. Specifically, I'm jumping to the 4th sentence there, but no evidence established, and the jury did not find that farmers should have done more to obtain a declaration, that one I spoke about there being no insurance. And farmers, on the contrary, the jury expressly found that farmers used reasonable efforts to obtain Orcutt's cooperation, and her lack of cooperation prejudiced the insurer. So the Court of Appeal found an inherent conflict in what the jury found, and found that the problem was the CACI instruction. Farmers, in the Court of Appeal's opinion, did everything it could to settle. That's okay, settle the case. So this was the CACI 2334 pre-Pinto, the one that was used in the Pinto case. It had simply 3 different parts to it. Fast forward, after Pinto, it was such an important decision that the CACI was amended, and now you have 7 different parts to that jury instruction. Okay, it's enough talking for me. I'm going to step back for a moment. I'd like to hear from Tamiko and her thoughts, having counseled clients with respect to this case, this particular case instruction on this case for our audience, and then I'll turn it over to Demián.
Yeah, I mean, I think that Pinto was really important, although from an insurer's perspective, it was rightly decided and was just merely affirming what, from the insurance perspective, what the law was and should be, i.e., when you're dealing with bad faith, it's a tort. It's the unreasonable, tortious withholding of policy benefits. And so, CACI in its prior form and the suggestion that there would be strict liability because a reasonable settlement offer is not accepted kind of flies in the face of that, right? There has to be unreasonable conduct in order to rise to that level of acting tortiously. There really does have to be unreasonable conduct. So when Pinto came out, it was definitely a validation of the insurer perspective of things. That yeah, of course, there needs to be something that was done unreasonably, and of course, there can be circumstances where a demand can be reasonable, certainly, but there are absolutely situations, and Pinto was a good example of that, of where you can have circumstances that can be outside of your control. And so to hold that the insurer, while it's unfortunate that an excess verdict is arranged, but if the insurer did everything they could, which the court really highlighted in Pinto, to come out and say, no, there was tortious conduct here, particularly in light of what the jury's findings were, it did seem to really follow what should have been settled before going into this. So
I think you'd used a word, Tamiko, when we were preparing for all this. You'd said that this was frankly clarifying, that the standard has always been you have to show unreasonable conduct, and that this clarified that. Okay, Demián, over to you.
Okay. So I remember the day that Pinto came out or the day after, because I still have one of these, I still have this practice of I pay for the daily journal and get the daily appellate report every day, and I read the blurbs, and I make my associate read the blurb, just like Jerry Mannion made me do when I was back, and I remember reading this thing and just I was shaking my head, because it's hard for me to argue that case was wrongly decided. I mean, I would have if I had been in mine, but when the facts that we've put up here are actually kind of generous, I think, to plaintiff's counsel, just from like the carrier was begging these guys to take their money, right? And look, this case was not one that ever touched my desk, but if it had, I would have said, don't go anywhere near this. Like, what is wrong with you? Sorry to be so frank.
In other words, take the offer. You would have counseled your clients.
Yeah,
take
you're done. You missed, I mean, it would have been interesting, and it's a bad injury. And I realize the client, is not going to get a full or even close to a full recovery on the case, but that's all there is. Like, you're not, going to this point though, that about this clarifying the law, the one of the interesting things about this decision to me is that it kind of did clarify the law. I mean, the jury instruction itself, CACI 2334, was very straightforward, right? It was a series of boxes: reasonable offer, failure to accept, excess judgment, pay, right? That was it. I was trying to pull up the version of CACI that existed prior to Pinto, the Pinto decision. The reason is that, and I'm sure it's out there, if you look at it, the very debate that the Court of Appeal resolved with the Pinto decision is laid out in the comments to the jury instruction. Like, it talks about there has been a significant amount of debate as to whether both the settlement offer must be reasonable and the rejection has to be unreasonable. Like, this is not a new debate. And it's actually enshrined in the instruction. We don't need to put it on screen right now.
That is in your handout materials for everybody in the audience.
Yeah. And so, but like, this was not a new thing. And so if I was, sitting at Tamiko's desk, right, this is the case that I was waiting for to get this cleared up. I like that the Court of Appeal talked about, well, what if an emergency prevents transmission of acceptance? Like, again, not a new hypothetical. I've got a practice guide sitting on my desk right now, written by a couple of former coverage defense lawyers. I'm sure Tamiko and Vedica, you know which one I'm talking about, where they raise this hypothetical. What if the adjuster's on his way to the mailbox and he gets hit by a bus? You know, is it still bad faith? Anyway, it was really hard to argue this one. And just the last point I'll make is, think about how angry these facts made the Court of Appeal, right? You know, I mean, I've been in practice 21 years at this point, and so I can't say that I've seen everything, but I don't know if I've ever seen another case where the Court of Appeal was so incensed by the facts that they reversed the verdict, invalidated a facially correct jury instruction, and ordered judgment entered for the opposing party, right? Like they say in there, no evidence suggested farmers' conduct caused the settlement to fail. They weren't trying that issue, right? That's how bad this was. So, bad facts make bad law.
No, and it's important to point out that even having sat on the bench myself, jury verdicts are considered sacrosanct because none of us know what is happening in that jury deliberation room. None of us. And that's the point. We're not allowed to go in there. The lawyers, the judges, just the bailiff is allowed to bring them back and forth for this reason. And that when a jury renders a verdict, it is given all kinds of deference. So this was a big deal case where you're exactly right. The jury instruction was found to be wrong, which then said, well, that means the judgment's wrong. And then reverse, not remand, reverse, and we're just going to enter it in favor of the carrier. So watershed case, it led to there was theories back in 2021 that maybe it'll be appealed, maybe the Supreme Court will take it up. Didn't happen. So it's the law of the land. So now, with that framework in mind, we go to what will be the heart of our discussion, which is the Hedayati case. This came down in August of 2021. Now, the facts are really also compelling. So I've put all of us worked together to put a bunch of information together. I'm not going to go through it all, but top level, Miss Hedayati was a 43-year-old medical school grad. She was actually studying for her board exams and taking a break when she was walking across crosswalk. Terrible car accident, hit by a car. The injuries were awful, folks. One leg severed, other leg shattered. She was in a coma, broken bones throughout her body. She was in a coma for a couple of weeks. And the driver, obviously recognizing this was a bad accident, tendered to, we're calling the insurance company the Auto Club so that we just shorten that full name. So moving to the next slide, this is the claims handling timeline. These are kind of the key facts that were happening in the October timeframe. So we start with one of the very first entries that the adjuster makes in the claims file is that the driver, quote, makes a very poor witness for himself, close quote. Now, these are important impressions. When you're an adjuster and you are noting things in the file and you are documenting your claims file, which the regs require you to do, these are key things for management to see and upper management to see because it will go directly to authority. Am I right, Tamiko?
Mm-hmm.
Yeah. So we go now to October. We're still in the October timeframe of 2012. During the initial interview, this is the same discussion, the insured gave his signed permission to release policy limits so that the Auto Club could move quickly to settle any potential claims if they exceeded his policy limits. The driver admitted that eyewitnesses told him he'd ran the red light. Sounds like he didn't quite remember exactly what happened, but he's being truthful with his carrier. The adjuster immediately recognized and explained to the driver that liability in excess of the policy limits was likely due to his speeding and hitting a pedestrian, even if we accepted only a percentage of the responsibility. Everybody's on board right away with kind of what happened, which is a little bit unusual. Sometimes it takes a while to figure out the facts of a particular accident. The adjuster's interview notes reflected that the driver disclosed that he had no other insurance. Again, these are the key things that are needed to put a settlement demand into effect and an offer into effect. No homeowners or umbrella policy. that he does not own literally anything, no real property. He is currently unemployed and living with his parents. So they know insured's financial status is, for lack of a better phrase, folks, no bueno. They know that they're going to be on the hook. The issue is, what do we do about it? Soon thereafter, now it looks like a manager is reviewing those claims notes and also reviews a newspaper account of the accident. So that tells you it made the local news. And the manager himself notes, it would appear that our 25K limit is gone. So everybody at Auto Club is kind of understanding the gravity of the situation based on what the Court of Appeal is showing, pulling out. These are the facts that the Court of Appeal highlighted for us. The adjuster drafts a letter to Hedayati's counsel that attached a copy of the insured's declaration that he didn't have any other insurance, an important piece of information, but somehow she didn't send that. Instead, the next day she sends another letter, a different letter, tendering policy limits, but not confirming the details that Hedayati's counsel sought. When you read the case, you'll see that Hedayati's counsel sought two key things right away: a declaration that there's no other insurance, as well as, I think it was course and scope, some basic things that are in the coverage universe very well known. Throughout, Hedayati's counsel was saying, I'm not getting that. So that's great that you've tendered the limits, but I need these other things to make sure the deal is done. So we move to November of 2012. This is when the formal settlement demand comes out. Now, we put a timeline together for you here because the most important thing about the Hedayati case, the timeline, is how this demand and the response came together. It was over Thanksgiving. It is the kind of emergency, quote unquote, that I think comes top of mind. And I mean, it was a perfect storm. So November 20th, that was a Tuesday. The settlement demand goes in conditioned on the declaration, not in course and scope, and that there's no other insurance. The demand had a time limit of 1 week. November 21 is the Wednesday, right before the Thursday holiday. Insurer receives the settlement demand. We have the holiday. Nothing happens that day. Nothing happens, apparently, the next day, which is a Friday, or the weekend, or the Monday. So now we're on Tuesday. We're a solid exactly a week, folks, November 27th. The demand has now expired. The insurer asked for an extension of time. Because it had expired, Hedayati's counsel said no. The Court of Appeal, looking through all the record, opined that the claims manager, quote, offered no explanation, ultimately, for why no one at Auto Club responsible for the insured's policy appeared to have seen or acted on Hedayati's offer for more than a week after it arrived. I will tell you, there's a lot of discussion in the opinion, literally about who was supposed to be looking. Was there an Auto Club employee that's supposed to go down and get FedExes and relay them up? Apparently, the demand did come up to a manager. Manager left early that day for a dentist appointment. So this is how critical the facts are for a time limit demand. So heads up for everybody involved. It's worth putting a chronology together. That's how I used to do my cases when I was a coverage lawyer. I lived and died by my chronology because every email, every timestamp actually makes quite a bit of difference. So this is the timeline of the settlement demand. And now settlement was declined. It was not, didn't happen. We go to trial. So in the case of Hedayati versus the driver, there was a $26 million judgment. Driver assigned his rights to pursue a bad faith claim. Hedayati sued the Auto Club for breach of contract in bad faith. In that case, Auto Club moved for summary judgment, saying, court, give me an order saying as a matter of law, I did not commit bad faith. And that is exactly what happened. Auto Club won the summary judgment, and the Court of Appeal did not like that. It did not agree. Here are some of the key quotes from that Court of Appeal decision. The trial court granted MSJ reasoning that the Auto Club never refused any of plaintiff's policy limit settlement demands. All plaintiff has shown is that defendant failed to respond by plaintiff's self-imposed arbitrary deadline to a demand defendant received the day before Thanksgiving for not just $25K, but also for a signed declaration from the insured attesting to certain facts. Although plaintiff's deadline to accept the policy limit settlement offer was the following Tuesday after Thanksgiving, now these are all the trial court quotes from their order granting the summary judgment. Plaintiff inexplicably required the response to be sent by UPS or FedEx overnight delivery, not fax or courier, meaning it had to be sent the Monday after Thanksgiving. I mean, the trial courts really delved into the exact facts of that settlement demand week. And then, quote, there was no real reason for the mega short deadline. And therefore, Auto Club's response or lack thereof was immaterial. That's how Auto Club was granted this ruling. We go to the Court of Appeal decision, which summarized the trial court finding right here. In essence, the court found no reasonable trier of fact could conclude Auto Club's conduct in failing to meet the clear terms of Hedayati's settlement offer and secure a release constituted a breach of its duties to the insured under his liability policy. In other words, the trial court found, I'm summarizing this quote, that Auto Club didn't violate the implied covenant of good faith and fair dealing. Court of Appeal, key words here, we disagree with this analysis. Now, folks, it is a big deal for us here to have with us today Justice Tom Goethals. He is the author of Hedayati. He is with me now on the panel at ADR Services, and I will tell you there's one thing that ADR Services does different that sets them apart from your other ADR folks, which is we have an amazingly collegial panel here. So when I called up Justice Goethals to say, hey, you're the author of this key thing that we're going to be talking about, would you come on board and talk to us? There was not even a little bit of hesitation. So let me just quickly give you Justice Goethals. He is on the Court of Appeal. Now, I was a trial court judge. You know, we get reversed all the time. We have to have the courage of our conviction. We do the best that we can do in the time, and then we don't worry about it until we get a decision reversing us. I will tell you, when we do get decisions reversing us, we think, well, now, is this Court of Appeal justice, was he ever on the trial court? Does he know what we go through? Let me tell you, Justice Goethals has done it all. He was a criminal lawyer, trial lawyer. He was a civil trial lawyer before he made it onto the OC Superior Court bench, where he sat for 15 years. Obviously, he was on the rocket ship to the Court of Appeal, where he sat for 8 years. And it is just thrilling, frankly, for us to have him here with us today to talk a little bit about Hedayati. Remember, he was a sitting justice. We can't just say, hey, what were you thinking? There are rules, there are ethical parameters, which we all must follow. But we wanted to introduce him, say hi to everyone, Justice Goethals, and ask you some questions if that's okay with you.
Well, you don't get out much, do you?
I love this work.
I'm here.
I love
nice
it. Okay.
Nice of you to have me. I'm just an old retired guy now.
Okay. So let me just do one more slide, Justice. I'm going to ask you some questions, but I wanted to introduce you to the crowd. So let's just look at slide 19 if we can, Katie. These are some of Justice Goethals' own words. This was part of the actual opinion. What it came down to in this opinion, from what I read, was that there was a material fact issue. The Court of Appeal felt that given the timeline, given the demand, given who the manager is going for a dentist, that there was simply too much to say as a matter of law. Auto Club did not commit bad faith. And I'm going to turn it over to Demián and Tamiko in a minute after we talk to Justice Goethals to tell us their thoughts about the case. But here are some of the key quotes. That the insurer may be liable for breaches of duties owed to the insured, such as the duty to investigate or duty to communicate. And here that was a big deal. A liability insurer has a duty to communicate any settlement offer that could affect the insured's interests. Well, we saw the timeline. Where was the communication with the insured about that settlement demand? That seemed to be a hook for the Court of Appeal here. Here, it's undisputed that Auto Club failed to convey Hedayati's November 20th settlement offer to the insured. Auto Club nonetheless sought to support its summary judgment motion by characterizing this failure as reasonable under the circumstances. Such an approach will almost inevitably raise contested issues of fact, as it did here. That is my emphasis. So turning it over to you, Justice Goethals, can I just ask some overview questions? If we look back at slide 3 for a moment, Katie. It's so interesting to us in the trial courts how the different divisions and the Court of Appeals may or may not work. So if we look at slide 3, which shows the different cases, Pinto, then Planet Bingo, then Hedayati. Planet Bingo was issued 10 days after Pinto, but didn't cite to it. And then your case, Hedayati, comes down in August, goes in detail into Pinto, but not Planet Bingo. Is there any magic to this? What's happening behind the scenes with the different divisions and these cases coming out fairly close in time to one another? Can you speak to that?
I think that's probably the primary explanation for why Pinto is cited. I did cite that and not Planet Bingo. Pinto came out first. The process, which most of you know in the Court of Appeal, is we have about a 5-month cycle on cases, maybe 6 months on some cases. The case is tried, it's appealed, notice of appeal is filed, the record is perfected. That all takes about a year. We're working through cases. This is just after COVID. And so I don't honestly remember Planet Bingo. I do remember as we were working through the case and I had written with a lawyer of mine a draft opinion before we heard the argument. I remember that Pinto came down, we read it, we talked about it, we put the language in that you referenced. Some of the language you folks talked about earlier is the exact language that we quoted in the opinion. And I don't really remember exactly how Planet Bingo factored into all of that. It was 10 days later. My guess is, just by the luck of the draw, we had finished writing a draft opinion. We were in the process of hearing argument. After argument, then I finalized the opinion and we circulated for signatures. That all takes a while. And so I'm just guessing that the opinion was probably just about done. We probably were aware Planet Bingo had come down. We didn't think it changed anything. Pinto was already in the opinion, so we just left it as it was. It didn't change our analysis. It is not, that's really not that unusual when you pull back the curtain. It is not unusual, doesn't happen all the time, but it's not unusual where we have a case and we are aware that another district has written an opinion and perhaps published it, maybe not. We're aware of unpublished opinions as well. So we're aware that another district rendered an opinion on a case that the issue is similar to one pending in front of us. And if I'm aware of that, I would read the case, whether it's cited, frankly, by counsel or not, I'd read it. And sometimes we just disagree. Right. And so there's no magic to that. Sometimes, that's part of the beauty of the system. There are the 6 appellate districts around the state of California with 100 justices, more or less, before you get to the Supreme Court. And most of the time we do actually agree, but occasionally we don't. So we issue a contrary opinion. So the districts or even the divisions within a single district might have conflicting opinions. And, we do our best.
That's the way it goes.
That's the way
right.
It goes.
That's how it goes.
And we recognize that if there are conflicts between the districts or even divisions within the district, almost every opinion I ever wrote, and I wrote over 1,000 opinions in 8 years on the court, everybody files petitions for review with the Supreme Court. That's just part of what you lawyers do. Nobody feels bad about that. That's part of the process. As you all know, about, I think it's 1%, maybe less, are granted review by the Supreme Court. So most of the time what we do is the final word. But if there are conflicting opinions between different districts or divisions within a district, we all know, because we've heard it at conferences from Supreme Court justices themselves or their staff lawyers, that that raises the likelihood that the Supreme Court might take the case and settle the law. And we know that. So sometimes we do it. We just do what we think is right on any case. That's the point.
Exactly. All right. Thank you, Justice, for that. Next question. So as we saw, the Pinto decision has a very detailed timeline of events built into it. And it put the timeline kind of under a microscope, and it really seemed to drive that decision. And while Hedayati certainly had a timeline of that, Thanksgiving and what happened with the settlement demand, it doesn't seem to rely as heavily on the claims handling timeline. Can you offer into any insight into why that might be?
Sure. I think I've heard the phrase bad facts from all of you. And this case had terrible facts, just like Pinto had terrible aggravated facts. Pinto resulted in a jury verdict, I think, of 6 or 8 or 9 million, something like that.
Yeah.
Hedayati resulted in a jury verdict of 26 million. Can you think of worse facts from the defense side than you've got a medical student who's studying, who's very accomplished, and it has, is a terrific human being, supposedly, from everything we've read. And she's studying for her board. She goes out to air her brain out, just like we all did when we were studying for the bar exam. And she gets hit by a car in a crosswalk. There's no liability issue at all. And a $25,000 recovery, as Demián said, isn't going to nearly compensate that plaintiff for even a small portion of the damage, but that's probably what it is. And the facts are different than Pinto, I think, based on what I recall of the record. Remember, folks, this was 4 or 5 years ago I wrote this opinion, so I have gone back and read it, but I haven't gone back and read the briefs and whatnot.
You don't remember this one out of the 1,000?
Well, I actually do remember this case.
I love it.
I remember it quite well. A couple of you have talked about, I think Demián mentioned that the Court of Appeal justices were incensed on Pinto, and Judge Pirro said that, we didn't like what happened the Court of Appeal didn't like what happened in Hedayati. We are all human beings. I mean, I was a trial lawyer for 25 years, and I tried a lot of cases in those 25 years. Then I went to the trial court, and I tried hundreds of cases as a trial judge, and then I went to the Court of Appeal. I'm married. I got kids, 2 of whom are lawyers. I've got 7 grandkids. I mean, I'm a human being just like everybody else, and I do see facts sometimes that sort of get my attention. But I can tell you, I can assure you, especially the adjusters who might be watching this, that we really, sitting on that court with 7 other justices for 8 years, I can't think of a single time when the fact that we had an emotional reaction to some facts that were bad facts really created what happened or was the background for the opinion. I can remember several opinions. I mean, I can remember a lot of opinions I wrote, but an opinion I wrote that I think was published was the granting of a motion for summary judgment, so the same issue as on Hedayati. And the facts of that case were even worse than the facts of Hedayati. It was just a horrible, tragic case. And I wrote the published opinion, a 2-to-1 opinion, in which we affirmed the granting of a motion for summary judgment. And I hated that. That opinion to this day sticks with me. And I won't bore you with what the facts were, but it was terrible. They were terrible facts involving 3 fatalities in a traffic accident. And the trial judge granted summary judgment because, try as we did, frankly, to find a disputed fact, I just couldn't.
Yeah.
And it was a 2-to-1, and I honestly thought we followed the law that the Supreme Court had created, and in my opinion, I invited the Supreme Court to look at the old case and revisit it, because I wished I hadn't had to grant summary judgment in that case, but I did. So there are cases that you have a sort of an emotional, personal, human reaction to, but that reaction very seldom creates the opinion in the Court of Appeal. That's one of the reasons I have nothing but great respect for trial judges. I was a trial judge for 15 years, and as I say, I tried hundreds of cases, and you make dozens of decisions every day. You don't have a brilliant staff. You don't have 6 months to look at every nook and cranny on every issue and to talk to other justices and to talk to your staff lawyers about it. I mean, you're making decisions, and most of the time you're right. Your instincts are good, and you take a minute. If you're not sure, you go look at the law. I did all those things, but everybody gets reversed once in a while, just because we're human beings, and everybody can make a mistake, and you can't take it personally. We never mean it to be personal, although some judges do, trial judges do take it more personally than others. I've had judges walk up to me at bar events that I knew, and say, you SOB, you reversed me on that case. What were you thinking?
Okay, well,
None of us took those kind of comments too well, and it didn't happen very often, but it did happen once in a while. So we
what
don't
I'm
take it,
hearing, what I'm
we
hearing,
try to
Justice
do the
Goggles,
right thing.
is we're bound by the law.
We're bound by the
Like
law.
it or not, we're bound by the law, and so we do our best to stay within that. I am thrilled to have you with us. Thank you. Please
Let me
do
just
stay
finish the
on.
answer, though. I got off on a tangent.
Oh, I'm sorry. Go ahead.
Let me tell you what happened. These are bad facts. I think the insight I can give you is, in terms of this case, and I think it may apply to Pinto, reading between the lines a little bit, reasonableness is essential to any analysis of bad faith. But I think before Hedayati, one of the things I wanted to write in Hedayati, which is in there, if you go back and read it, is I think the trial court, and I forget who the trial judge was in this case, but my recollection is it was a pretty good, experienced, respected trial judge. But I think the trial judge may have focused too much in his or her analysis on the conduct, the reasonableness of the conduct of the person, of the plaintiff and the plaintiff's counsel. There was a lot of comment and analysis on what the plaintiff's counsel did
Yes.
and the reasonableness of a 7-day deadline over the Thanksgiving weekend and all of that. And what I wanted to emphasize and did emphasize in the opinion is reasonableness is the standard. Reasonableness is essential to any analysis of bad faith, but reasonableness is a totality of the circumstances analysis, and it doesn't just apply to the plaintiff and plaintiff's counsel. It applies equally, potentially at least, given whatever the facts may be, to the conduct of the insured. And really the analysis here did not focus at all on the reasonableness of what the insured had done. And I felt strongly, the other justices felt strongly, my staff felt strongly that we needed to make a statement and clarify that. Also remember, this was a motion for summary judgment. Where I quoted from Pinto was right after I said, we don't know what's going to happen when this case goes back for trial. We're not commenting on the merits. And frankly, once in a while, I would go back and monitor the case. I never found out what happened in this case. My guess is they settled it. If both sides were reasonable, my guess is this was settled without another trial, but I don't know that. But it was a situation where if it went to trial, the judge needed to instruct the jury on a totality of the circumstances, reasonableness analysis, focusing not only on the plaintiff's conduct,
But on the
defendant's
insurer.
conduct.
Right,
And that's the
exactly.
point, the biggest takeaway we wanted to have. And again, pretty bad facts. Go ahead. That was a long answer. I apologize.
No, that's great. It was the takeaway, and that's exactly the point that was made, is we have to look at the insurer's conduct in the bad faith context. So Hedayati is the only case, folks, that exists out there right now that has delved into and really gone into Pinto. So in the post-Pinto universe, it is I would say, most important thing that we're looking at right now. And there are still no published decisions about the revised CACI 2334. It still stands. I'm going to fast forward us a little bit. Thank you again, Justice Goethals, for your comment. It's fantastic to have you with us and on the panel
Nice
with
to
me.
be here. Thank you for having me.
Of course. So we're going to fast forward a little bit, folks. We have some slides. You'll see them in your materials about the other case that's at issue here. That's Planet Bingo. I will tell you, Planet Bingo has a very, very tortured set of facts, and it's literally what I typed out to make it make sense is about 3 pages. I will send you it as a handout so that you don't have to reinvent the wheel. It's an interesting case because, quickly put, it held that the existence of an opportunity to settle within the policy limits can be shown by evidence other than a formal settlement offer. That's all I'm going to say about Planet Bingo. I want to turn it over to Demián and Tamiko to say anything they would like to add to us as we talk through and finish up here with Hedayati, and then we're going to do a quick session on CCP 999. So Tamiko, let me start with you. Any thoughts on Hedayati and what the justice had to offer us today?
Well, yeah, I think the justice was right. Absolutely on point with respect to reasonableness being a totality of the circumstances. And having these 2 cases come out so closely together was really helpful, because they really are 2 counterpoints to one another when you're looking at what was the bounds of what qualifies as reasonable or not. Hedayati in particular, it's a cautionary tale. It's the court was very clear on pointing out that the demand could be found to be unreasonable, but you have to look at the conduct of the insurer. And in that case, it was really, stark between Pinto and Hedayati as to all the efforts taken by the insurer in Pinto versus no efforts taken, even with the surrounding circumstance in Hedayati. The other key thing from Hedayati that got brought up was this safe harbor thing that the insurer tried to argue that they had tried to tender the limits at one point in time, although those weren't accepted for various reasons, and tried to use this safe harbor as a shield. And the court rejected that and said, no, it really is looking at the totality of the circumstances again in terms of what's reasonable at the various times. So really looking at these two cases, I think, are very helpful in kind of the bounds of reasonableness when you're approaching these time-limited demands.
Thank you, Demián.
Yeah, I mean, I would echo everything that Tamiko honestly just said. I mean, these cases are sort of opposite sides of the same coin. I love what Justice Goethals pointed out, which is, A, you got to focus on the insurer's conduct here. They're the ones with the duty of good faith. And B, the fact that it was an MSJ instead of a trial, right? So that's huge to me too. Well, could they be found unreasonable? Well, you got some stuff on both sides. The thing that's one of the things that stuck out to me also about Hedayati is the adjusters note that our $25,000 is gone, right? To me, that echoes an older case that is not cited in Hedayati called Crits versus Farmers. And that was a case where Farmers found itself on the other side than it did in the Pinto case. And that was a case where there was a 24-hour deadline to accept. And the carrier didn't meet that deadline. And the Court of Appeals said, yeah, sorry, you pay the excess. And in that case, there was a lot of documentation in the claim file that showed the carrier knew that it was going to have to pay its limit. Right? It's not unlike this. Like one of the first comments in the file was by the adjuster saying, yeah, this is going to be over. The safe harbor thing to me, though, is also just huge. That's crazy because not crazy, but it was very surprising and represented what I thought was a new development.
Okay, guys, that's our collective thinking about Hedayati and its impact. Katie, I know we're running down on time here. So
I do want to pop on just to comment that we're towards the end here, but our speakers did agree to stick around for a few minutes. So I wanted to capture any closing thoughts before we release, folks and switch to the Q&A portion.
So the last thing we wanted to talk about, frankly, it can be its own whole CLE program, is about CCP 999. The last slide 23 in your packets, just briefly summarize I think it's 5 sections that fall under 999. This is the first time, folks, so since January 1, 2023, that's when this statute came into effect, that the legislature has really taken a stab at defining for us what would or would not qualify as a reasonable demand in a pre-litigation setting. And it's certainly instructive. There are very specific terms. It applies to only certain insurance policies, but you can bet your bottom dollar it's a good guideline if you have other policies at issue. You'll see it right here on the slide. What I've summarized quickly, what each section is supposed to be about. Please actually read the sections. We'll include them in your handout so that you have them because they're very specific. I know we don't have time to all talk about the impact, but the one thing that all panelists agreed on was this will surely generate some more case law because there are terms within the statutes that are still a big question mark as to what they mean. But do your best to follow them, talk with your clients about them, have them in front of you if you're framing a demand, have them with you if you're responding to a demand. That's all I'll say. Thank you again to my panelists for being with me and the justice for coming on in and being the star of the show today. Katie, I turn it over to you. I know we had some questions. If people have questions, great. We're happy to stick around for a few minutes and answer them for you.
Thank you. Yes. So as everybody is heading out, just a reminder that your CLE certificates will follow via email within the next week. Please keep an eye out for those and check your spam filter if you didn't see them. The materials are going to be included in that email that I will send out. Additionally, we have a copy posted in the chat. You can also find them on the ADR Services Inc. website login page for this webinar if you want to go onto the CLE program page. If you head out now, you will get the full CLE credit or welcome to stick around if you have a few more minutes. As you leave the webinar, whenever that may be, you'll be directed to a short survey. We really appreciate if you take a few minutes to respond to that and let us know how we did, and especially any thoughts for future webinars you'd be interested in. We always read all of those responses and really try to give you programming that you are interested in learning about. And with that, I'm turning it over to the Q&A. The first thing, this wasn't a question from the audience, but a question from me is, Demián and Tamiko, was there anything that we talked about during kind of the planning sessions that you didn't get to talk about during the program today that you really want to mention? I'll start with Demián.
Yes. And if I start talking about it, we'll be here.
That's my bad.
Yeah.
Poor for me.
Yeah, exactly, Katie.
Yeah, I mean, there's so much to this duty to settle, right? And so if we start talking about all the other fine points of this, we'll be here for another 2 hours, which I would love.
I know it's fine with us, but
yeah, I mean, there's how 999 was a reaction to Pinto, and just anyway, the duty to engage anyway. Sorry. No. So short answer is yes, but I don't think we need to open it up now.
I think the one thing that we all talked about and agreed about is just how prevalent of an issue this is becoming, and rising jury verdicts, and so policy limits demands. I mean, I've been practicing in insurance coverage for over 20 years, and I mean, just the huge uptick in seeing these come across my desk is pretty, in the last few years, it's been dramatic. And so being versed in tracking these issues and getting whatever guidance you can get about what a court or a jury or otherwise may think about what is reasonable dealing with these circumstances is so important, because it's just becoming such a huge issue that people are dealing with daily almost.
Agreed.
We have a couple of clarification questions. I think that you did cover this, but somebody asked pretty early on in the Pinto decision, the court decided that the insurer did not act unreasonably by failing to secure a declaration. Does that mean that the duty falls on the insured to secure a declaration, or does the insurer just need to act reasonably under the circumstances?
It all comes down to the reasonable standard and what that means. So if for the case where farmers tried and got information but just couldn't get the insured to give us a deck, that's going to be considered reasonable conduct. They did what they could to get the information. So I don't think it's a duty. My 2 cents is it's not a duty for the insured, but definitely for the carrier to help secure it and do their best to do that. Any additional thoughts, Demián or Tamiko, on that?
I mean, I think you can have issues if you're dealing with your insured having to be involved, and cooperation issues can come up there. I think Pinto was a particular case too, because the declaration was being sought from a permissive user. So it's not even somebody that's insured under the policy. So, the connection between the insured and the insurer and cooperation issues might not be there to the same degree. I mean, you may still have some issues. So yeah, I mean, the obligation is on the insurer to act reasonably and appropriate and do what's within its power. And part of what's within its power is having to work with the insured. And all of those issues and all of those facts are going to come into play when you look at the reasonableness of the conduct.
And I would make a comment on that as well, which is that, the change to the 2334 instruction created new uncertainty for the plaintiff or claimant, right? Because of this introduction of the specific requirement of unreasonableness on the carrier's part. You don't know what, like as the plaintiff's lawyer, you don't know what happened in there, right? And there's no obligation for the carrier or the defendant or their lawyer to share any of that information with you. So what I, as a practice pointer, what I tend to counsel people to do is avoid that, right? You know, if you're the claimant or the plaintiff, right, you know, you got to comply with 999 if it's pre-lit or whatever, but right, make it as easy as possible for the insurer to say yes to your demand and not have any excuses for why they would have said no, right? And that kind of goes to everything, right? It's not just the declaration, but it's the timing, right? It's the, you know, the specifics. I mean, the carrier should, if they want to be good about it, come back to you and you know, and do things to really try and facilitate it. But like, why make it hard for them? You know, so
Fair point. And that's how you counsel your clients. That's your advice to them.
So no straight answer on that.
Imagine that.
It's something you pointed out, Demián, during the presentation, and it touches on all of this. I mean, the totality of the circumstances. And so, yes, you're looking at the reasonableness of the insurer's conduct, but when we look at these decisions, the context of what's going on all sides comes into play and forms the lens through which the court's going to be looking at this or a jury's going to be looking at this. So, yeah, I think that's a good thing to take away is reasonableness and how you conduct yourself is going to be looked at from all sides.
100%. 100%.
Well, in cognizance of everybody's afternoon and time, I think we are going to wrap up here on those excellent final suggestions and practice pointers from our speakers. Thank you all so very much for sharing your thoughts with us and to Justice Gothel's in the wings. We really appreciate all of you attending this afternoon and spending your lunch hour with us. And thank you so very much to our wonderful speakers.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.